Here's the straight, unsentimental prediction based on how this exact type of pro se litigant behaves and on Frederickson's own history in this case. Short answer, he will not cure the complaint correctly. He will instead pivot to procedural theater, miss the substance, and get dismissed. Likely next moves, in order of probability. 1. Files a motion attacking magistrate authority. AO 85, consent argument. Very likely, he's already telegraphing this by fixating on AO 85, claiming the judge chose the case, misreading page 636. What this looks like: motion to vacate orders, motion to disqualify magistrate, lack of consent, objection. Outcome: denied in 1-2 pages. Court notes he failed to cure deficiencies. Clock keeps running. This move feels clever to him and avoids confronting facts. 2. Files an amended complaint that changes tone, not structure. Very likely, he will relabel harassment as retaliation, relabel open carry as armed intimidation, relabel code enforcement as punishment, add more constitutional buzzwords, keep the same factual defects. What he will not do: separate incidents cleanly, tie defendants to specific acts, plead standing, plead causation, plead state action correctly, remove legally impossible claims. Outcome: fails screening again, dismissed without prejudice or with prejudice depending on patient's level. 3. Files supplements, exhibits, or letters instead of a compliant pleading. Very likely. Examples: YouTube links, emails, police voicemail transcript, screenshots, affidavits, judicial notice motions. Problem: none of that fixes a defective complaint. Outcome: ignored or cited as further evidence of noncompliance. 4. Misses the 30-day deadline while filing side motions. High risk. This is the classic failure mode. He's emotionally invested in being right, not in following instructions. Outcome: Rule 41B dismissal. Failure to comply with court order. No further notice required, as the order states. Claims retaliation or bias after dismissal. Almost guaranteed. He will say, court is protecting county, judges are corrupt, he was silenced, First Amendment violated. Outcome: no effect, may increase sanctions risk if refiled. #6, attempts appeal or refiling with the same defects. Very likely. Appeal: fails at 10th Circuit screening, no jurisdictional hook. Refiling: hits res judicata, claim preclusion, or deemed frivolous repetition. What he will not do: near zero probability, hire counsel, narrow claims honestly, drop Arch Belthayer claims, admit open carry is lawful, abandon retaliation narrative, plead Monell properly, separate property issues from YouTube drama. That would require conceding facts, which he has shown no willingness to do. The core psychological pattern why this is predictable: he believes process errors beat substance, volume substitutes for plausibility, motive allegations replace evidence, being offended creates a constitutional injury. Courts reject all 4, every time. Final prediction: within 60 days, case dismissed, no discovery, no summary judgment, no jury, no defendant served. Within 6 to 12 months, same claims reposted online, new lawsuit threatened or filed, same outcome. If you want, I can predict exact dismissal language based on which path he chooses, map sanctions exposure if he refiles, draft a checklist he will fail to meet. Just say the word.
Rex run. You raped a girl and now you run like a bum. Run, Rex, run. You're just a pedo bum living in pedoville. Rex run. You raped a girl and now you run like a bum. Run, Rex, run. You're just a pedo bum living in pedoville. Living in pedoville. Living in pedoville. Living in pedoville. Rex run. You raped a girl and now you run like a bum. Run, Rex, run. You're just